Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is episode 15 of the Maxwell Files. Today has been a pretty crazy day. It has been a whirlwind of activity in Judge Preska's courtroom. Ghislaine Maxwell's team is working overtime to try and keep these documents from the public. And Judge Preska has pushed back against Ghislaine Maxwell and her team, even going as far as saying that Maxwell is attempting to muddy the waters. Her exact words. Where have you heard that before, huh? Who else is always talking about them trying to muddy the waters? Because it's obvious that that is what they're attempting to do. So, we are still waiting for the documents to be dumped. We're still waiting for the sealed documents to be released to the public. And it looks like this could be, the waiting game that we thought it would be. Now, right now in New York, it is 5:42 p.m. So just because the courts are closed does not mean that things are not still being filed. The law clerks are hard at work, I'm sure. And I think a case like this, we're going to see it work its way through the system. It could possibly be even later on tonight. I mean, again, who knows when it comes to the federal courts, right? It's a whole lot of legalese, a whole lot of mumbo jumbo, and a whole lot of nonsense for the most part. But Preska is not playing games with Ghislaine Maxwell's team now, and she is ready to get these documents out and to the public. So we're going to go over an article from Law and Crime that was released about a little over an hour ago. So it's pretty up to date on where we stand. The headline: Ghislaine Maxwell's lawyers make several new moves to keep Jeffrey Epstein files hidden from the public. The author of this piece is Jerry Lamb. Ghislaine Maxwell on Thursday made several moves in her fight to prevent a series of currently sealed documents from being publicly released by day's end. And that's important too, because as Adam Klasfeld also mentioned, it is the day is not over until midnight, right? So I guess we have up until midnight to see these documents put into the public display, into the public record. And I'm not well versed at something like this, right? I don't sit around and follow court cases and know all the ins and outs. But if you're not following Adam Klasfeld on Twitter, you definitely should do that. He's a court reporter and he is way up to date on the legalese in this case, right? So according to him and according to what they say here, I would guess that we have until midnight for this stuff to be entered into the docket. First, Maxwell's legal team appealed a federal district judge's decision ordering the release of the files. Hours later, one of her attorneys filed a letter to the same district judge claiming that the opposing party failed to properly redact the documents in accordance with the court's order. Basically, loopholes. What they're trying to do is stall. Ghislaine Maxwell and those around Ghislaine Maxwell, those involved with Ghislaine Maxwell and Jeffrey Epstein, understand the stakes. They understand that these documents are going to be damning. They understand that they have zero chance of controlling the narrative once these documents come into play. So they're going to do everything in their power to muddy the water, to drag their feet, in hopes that something will change and something will bounce their way. Well, folks, I think they've run out of good luck charms. No more rabbit's feet for Ghislaine Maxwell and her friends. After a hearing last week, U.S. District Judge Loretta Preska of the Southern District of New York on Tuesday ordered multiple documents related to a now settled defamation case against deceased sex offender Jeffrey Epstein and Maxwell to be released to the public no later than Thursday, July 30th. So again, I believe, according to Adam Klasfeld and to what we read here in the article, that we have until midnight Eastern Standard Time for them to comply with the judge's ruling. Now, again, I am not an expert when it comes to this sort of thing. I'm just, muddling my way through it like the rest of you, trying to make heads or tails out of all of it. When it comes to this sort of thing, the legal portion of the case and how these things work, I definitely defer to people like Adam Klasfeld and people like the author of this article. This is what they do. This is what they're good at. And I think that Law and Crime and Mr. Klasfeld have both done fantastic reporting work here in this case when it comes to the trial, etc., etc. So I'm definitely using them as a guide here as we move along throughout the day. Per Preska's order, the parties were tasked with redacting the documents of 1. Personal identifying information as to any person mentioned in the documents. So I'm guessing that would be addresses, home addresses, stuff like that, right? I don't know if that would include the names. I don't think so, unless of course it's a non-party, somebody who is not involved. Again, kind of murky, right? I guess we'll see. 2. The names of non-parties other than Does 1 and 2. So again, nobody who is a non-party to what was released in the deposition or the case will have their names or information unredacted. But I think that Does 1 and 2 will have their names in full view here. So I'm guessing that Does 1 and 2 are Dershowitz and maybe Glenn Dubin. I don't know. I'm torn, but I'm pretty sure that one of them is definitely going to be Dershowitz. And what that means is that besides those two Does, I'm guessing that we'll have some redactions of other names in this first dump here. And 3, other portions related to such non-parties' specific conduct. And again, that's pretty vague, right? I guess we'd have to see the whole thing to know exactly what we're talking about here. I won't even take a guess at what they mean there because I honestly have no idea, folks. In the letter, Maxwell's attorney claimed that the redaction submitted to the court would fail to meet those standards. And of course, they have had plenty of time to go over these redactions. They have had plenty of time to take a look at all of the information provided, and they waited until the 11th hour in hopes, with the weekend creeping up, that they'd be able to drag their feet and buy themselves some more time to find ways to navigate through these loopholes. Plaintiff proposes to unseal significant portions of the testimony which would not only identify the non-party at issue, but also their alleged conduct, both as alleged perpetrators of sexual misconduct and also as alleged survivors of such conduct, her attorney Laura Menninger wrote. See, they add the part about the survivors here to try and give their claim credence, right? If they were just saying, well, this could release the information of those perpetrators who were alleged to be involved with misconduct, well, that wouldn't really go over so well, right? So they add the survivors in there, and they think that's a nice touch, and they're in hopes that will sway the judge to give them, a split the baby type of situation. The letter requests that the court allow Maxwell to submit her own redactions under seal before publicly releasing the documents. She should have done that a while ago. This was ruled on the 23rd. They've had a week to go through this. They've had more time than that to go through and redact things. So this is laughable on its face to me. Maxwell's attorneys also filed to appeal the SDNY's judge's release of the documents. Paperwork in that case was still being entered into the docket at the Second Circuit Court of Appeals at the time of this writing. So, about an hour and 20 minutes ago, there was still paperwork being filed to the docket that's supposed to go in front of the Second Circuit Court of Appeals no later than Monday. So we see in real time how Ghislaine Maxwell and her lawyers were attempting to drag their feet here, muddy the waters, and make it confusing. That's what they want. They want it to be confusing. They want to make sure that these documents never ever see the light of day. And if they can manipulate the court system to their own purposes, then that is exactly what they will attempt to do. But I have to tell you right now, I highly doubt that this is going to play. Again, as far as the Second Circuit Court of Appeals go, if we're talking about precedent, then I highly doubt that this will ever be even looked at seriously by them, right? But we're in an especially weird time right now. I know personally, I've never seen something like this happen in a case, right? Where we have this civil suit and the criminal case. This is, uncharted territory and uncharted waters. So I really have no idea, and I'm not even willing to make a prediction which way the Second Circuit Court of Appeals is going to go. But if they use their own standards and they rely on precedent that has been set in their own courtroom, well, I would think that they would be leaning towards unsealing everything that Ghislaine Maxwell wants to keep sealed. Preska, the district court judge, on Wednesday evening rejected a request from Maxwell's attorneys to reconsider the original ruling. However, anticipating an appeal of her decision, Preska agreed to postpone the unsealing of some of the files. And again, that's where a lot of the confusion was coming in, right? Some of the files, not all of them. The deposition files were the ones that were being pushed back until Monday to give the appeals court a little bit of time to do a bit of a look-see. So there has been a lot of confusion over that part of what's going on today, and it's understandable. Look, again, I am certainly not a lawyer. I took a criminal law course, criminal justice 101 in college like everybody else. But besides that, I most certainly am not a lawyer here, and I'm just attempting to navigate my way through all of this just like you folks are. But I will tell you a few things. And one of those few things I do know about this kind of stuff is it is not quite often that an appeals court would go against precedent that they have set in their own court. The underlying case here is a defamation lawsuit filed by Epstein survivor Virginia Roberts, who has been speaking out since 2011 when the United Kingdom's Mail on Sunday published an article alleging that Epstein and Maxwell furnished her to Prince Andrew while she was in Epstein's clutches of his sex trafficking ring. And look, it makes me agitated, by the way, that she had to go to the Daily Mail to get this out. Where was the legacy media in the United States? What were they doing? Were they too busy to cover this story? So busy that she had to go over to the UK to be listened to? It's absolutely ridiculous, but it's just another slash in the column of the legacy media being an absolute dumpster fire. The still sealed materials are widely believed to contain highly sensitive and likely embarrassing information about those who associated with Maxwell and Epstein. The documents slated for release include Maxwell's 2016 deposition, her correspondence with Epstein, and a deposition from attorney and former Harvard Law School professor Alan, I kept my underpants on, Dirty Dershowitz. Dirty Dersh has staunchly denied allegations that he engaged in any sexual activity with any of the girls or women associated with Epstein. And of course, if you listen to him tell it, it's because he kept his underwear on. How could he ever do anything so crazy if his underpants were still on? That's this guy's excuse, okay? That's the extent of it. Maxwell was arrested by federal authorities earlier this month and charged with enticing a minor to travel to engage in criminal sexual activity, transporting a minor with the intent to engage in criminal sexual activity, conspiracy to commit both of those offenses, and perjury in connection with a sworn deposition. All right, so this is where we stood about an hour and a half ago with Law and Crime bringing us up to date on all the different movements within the case. Well, Preska has responded. In a 4-page ruling, here is exactly what Judge Preska responded with. Loretta A. Preska, Senior United States District Judge. The court is in receipt of defendant Ghislaine Maxwell's letter dated July 30th, seeking to submit under seal her proposed redactions to the materials ordered unsealed by the court's July 23 order and raising issues with the proposed redaction submitted by plaintiff Virginia Roberts, docket number 1083. The court is also in receipt of Ms. Roberts' response to that letter, docket number 1084. Prior to receiving Ms. Maxwell's latest last-minute request, the court conducted an in-camera review of plaintiff Virginia Roberts' proposed redactions to the materials, which are described in Ms. Roberts' letter dated July 29th, docket number 1080, and which were provided to the court late in the evening of July 29th. Having heard nothing from Miss Maxwell late this morning, the court, upon completing its review, prepared an order for docketing that 1. Found Miss Roberts' proposed redactions, which include minimal redactions of personally identifiable information, the names of non-parties, and descriptions of non-party conduct that would allow the readers to discern the identity of a given non-party to be appropriate, and 2. Order the parties to proceed with unsealing the materials in the manner set forth by the court's orders of July 28th and July 29th. See docket numbers 1077 and 1079. The court elected not to issue that order so that it could address the request contained in Miss Maxwell's letter and any additional issues raised in Miss Roberts' response. First, Miss Maxwell's request to submit her own proposed redactions to the court under seal for in-camera review is denied. As Miss Maxwell well knows, the court on July 23rd ordered the parties to prepare the relevant materials for unsealing by today. While Miss Maxwell gripes that Miss Roberts submitted her proposed redactions to the court late on July 29th, docket number 1083 at 1, Ms. Roberts at a minimum gave the court time to conduct a review of her proposed redactions while preserving the original schedule for unsealing. This is bad news for Maxwell and her team, in my opinion here, folks, because this is the judge is basically reading her the riot act. By contrast, Miss Maxwell, at 2 p.m., informed the court that she is finalizing her proposed redactions and that she will be ready to provide them to the court at some undefined point today, ID at 2. On top of this, and despite the court's instruction that the parties work together to ensure that materials were properly redacted by the appointed time, Miss Maxwell apparently has not provided to Miss Roberts her proposed redactions either. And this should come as no shock to anybody. Again, this is how they play. This is the game that they have been playing for years. Docket number 1084. For reasons that should be plain, this is entirely unworkable. Second, the court adheres to its planned order, see supra at 1, and approves as appropriate Miss Roberts' proposed redactions to the sealed materials. The court does so, however, subject to several caveats. Miss Maxwell contends that Miss Roberts' proposed redactions contain errors which reveal the names of non-parties, including alleged survivors. Miss Roberts suggests in her response that any unredacted non-party names may have already been released by the Court of Appeals, but otherwise acknowledges that it is possible there were errors in her proposed redactions, docket number 1084. To the extent that non-party names appear on pages that have already been unsealed by the Court of Appeals, they need not be redacted. To the extent that non-party names appear on pages that have not been publicly released, those names shall be redacted. Names of non-parties' family members that could be used to identify the non-parties, to the extent that they are not already public, shall be redacted. So basically what she's saying here, if I'm reading it correctly, is if your name has not been brought into the public view already, and it's not somebody that has come forward or somebody in the case who has been named, then those names will continue to be redacted for now. Counsel shall accordingly proceed with unsealing the relevant materials by the method prescribed in the court's July 28th order, docket number 1077, and modified by this order by the court's July 29th order, docket number 1079. So ordered. New York, New York, July 30th, 20. Judge Loretta A. Preska, Senior United States District Judge. Wow. All right, so that's where we're at. That's where we're at. It looks like Judge Preska has had enough of the nonsense when it comes to Ghislaine Maxwell playing games here, and most certainly she's had enough of the nonsense when it comes to the muddying of the waters, right? Dragging her feet, etc., etc. She's not playing games anymore with these people, it would seem, and she's trying to do everything in a proper manner, though, so that there's no wiggle room for these people. At least that's the way it looks to me. So I'm very interested to see what's going to happen today, what's going to be dropped when it comes out, and I will continue to monitor the situation. And once the files are put into the public view, I'll be back. Obviously I'm going to go through them, and then we'll read some of them on the air. We'll check out what the news is saying about it, what articles come out, and we'll try and get as close as we can to some point of understanding about what's going on here, folks, right? Because it's a lot. There is a lot. When it comes to the legal portion of this case, it is very confusing in a lot of regards, especially when you're not used to the way the legal system works. It seems like there's some sort of, nonsense going on. And all I could say is, this part of the case that we're at now, when it comes to the wrangling in the courtrooms, this is where it gets real interesting. This is where the rubber meets the road, and this is where we're going to find out just how serious the federal government is about bringing justice in this case. If you'd like to contact me, you can do that at bobbycapucci@protonmail.com. That's BOBBYCAPUCCI@protonmail.com. You can also find me on Twitter at BOBBY_CAPUCCI. All of the links that pertain to this episode can be found in the description box, and that includes the judge's order that I just read. So make sure you click on the article link, you check out the article, and you could read the order yourself right there. And to all of you who have donated to the GoFundMe, thank you very much. And like I said, at the very least, I'll have one more episode today, but there might be more. Depending on what the news is, that will dictate how much more content I produce today and how many more segments pop out. Until then, folks, I hope everybody has a great day.